Sir, the virtual stage is yours now, and maybe we can start with a little address on cross examination for young lawyers.
First of all, I'm grateful to you for bringing me on this platform. And I would start by saying that cross-examination is the most significant component of a criminal trial. Why I am calling criminal trial over civil trial is because many criminal trials are primarily based on oral evidence, whereas in most civil cases, you have documentary evidence. So therefore, the scope for cross-examination is reduced. And in a criminal trial, cross-examination is critical. It is the only means for an accused to establish his innocence. Because when an FIR is registered, it is only the complainant's version. Then when investigation is conducted, it is with the perspective of the complainant, the victim of the crime. Then we move on to cognizance, again only the version of the complainant. Further moving on, when charges are framed, it is only the version of the complainant or the prosecution that is considered. Then evidence is led on behalf of the prosecution. That again is one-sided. And here comes the importance of cross-examination. Cross-examination is the only means to find out the truth. For the accused, it is the only means to establish his innocence. So therefore, cross-examination is a critical component of a criminal trial. Having said that, cross-examination, in my view, is a dying art. It is a dying science, because I find youngsters, the brilliant youngsters coming from the best of law schools in the country, they are all having a tendency to flock around corporate law, business law. They want to join law firms, and therefore I find very few brilliant young lawyers entering the arena of criminal trials. You have some youngsters coming in, again they want to focus on economic offenses, white-collar crime, but very few intelligent, brilliant youngsters want to do cross-examination in heinous offenses. So cross-examination is a dying art. You have very few good cross-examiners left in Delhi or in the country also. And I find that most lawyers, don't study the case and they are just groping in the dark while cross-examining the prosecution witnesses. Now, since most of the accused are languishing in jail, or they come from poverty-stricken backgrounds, they are uneducated, so therefore they don't have the means of even finding out the quality of the cross-examination which is being done by defense lawyers. Therefore, I will exhort the young lawyers coming from the best of law schools, please, please, please also consider practicing in the trial court. Also consider developing the art of cross-examination, the science of cross-examination. It is a fascinating facet of criminal practice. Let me tell you that. The highest point of my law practice is, has been to cross-examine. I must have cross-examined over maybe 700 to 800 witnesses. Of course, now, since I've been a senior counsel for the last about 10 years, the opportunities to cross-examine witnesses has substantially come down. But wherever I get an opportunity, I jump, I grab that opportunity even today. Because that is a fascinating part of the criminal law practice, cross-examination. So with this background, we can initiate the discussion. I will be happy to answer all your questions.
Right, sir. Sir, like you said, diversified रहता है. Everybody has, different ways of going about it. Everybody has different tastes also. We are being joined right now by half a room on Zoom and about 400 to 500 people on social media. Now everybody has different experiences. सब लोगों का तरीका अलग है, सब लोगों के mentors अलग रहे. And इसी तरीके से सब लोगों की strategies भी अलग हैं. So now that you are here, आपके पास almost 4 decades का experience है, and you are so thorough with things. First question that we have on the list is that what is one strategy, if you could share with us, कि ये एक चीज है जो mostly cases में fit होती है. This is how you should go about your case. Prepare a cross examination, identify weak spots in the evidence, and cross examine.
Okay, so the one strategy, if since you have asked me for that one mantra,
That's for the paucity of time,
not
sir. If you want, you can share more.
very well. So I will share a few important arenas, the important mantras for cross examination. First of all, first and foremost is preparation. Without preparation, it is not possible to effectively cross-examine witnesses. Now, by preparation, I don't mean that you must formulate all the questions. Of course, I would do that. In my initial years, I would pen down the questions. Later on, with experience, I would pen down the areas of cross-examination. So that became a summary. And with more and more experience, I could then, make a very brief summary as to what are the questions, what are the areas in which I will question. So preparation is of foremost importance, firstly. Secondly, the second important mantra is to understand the witness and understand what evidence he has come into, for what evidence he has entered the witness box. So if you have a grip, if you have a thorough grip on the case, now what is meant by the case? Now let me elaborate a bit. What do you mean by a case? You must understand thoroughly the prosecution story. See, in most cases, I represent the accused. So I'm going to give you the perspective of the accused. You must understand the prosecution story thoroughly. What is the prosecution case? How the prosecution seeks to prove its case through the witnesses. Accordingly, you prepare your defense. Now, therefore, the second important aspect is to know your defense. You should know where your off stump is, as they say. When you're playing cricket, when you're batting at the highest level, if you hear Sunil Gavaskar and the other legends, they will say you should know where your off stump is. You're not looking that side. So you should know your defense. That is second. And the third important aspect is to know your witness whom you are going to cross-examine. You can now judge, you can find out your witness through his 161 statement, section 161 statement, the evidence he has given, from what strata of the society he is coming from. Is he a police witness? Is he an eyewitness? So understanding these three important areas, in my view, with these three important areas, you can build up a concrete strategy of cross-examination.
Very well, sir. So going forward, we also come to hear a lot on this point कि आपको अगले बंदे की साइकी समझनी जरूरी है. You, as a lawyer, when you're cross-examining somebody or you are in the court representing, you have to know the psyche of the person you're talking to. It could be a judge that you might want to understand. It could be the person you are cross-examining that you have to understand before you start cross-examining. Just like you said कि कौन से strata से आता है आपको ये समझना जरूरी है. So the second question is, what are some psychological techniques and questions that you can share with the lawyers and they can apply in their matters?
Generally, my strategy, whenever I have cross-examined witnesses, my strategy, I'm sharing a secret with all of you. My strategy has always been the rapid fire strategy. I have never given an opportunity to the witness to settle down. Many lawyers will give that opportunity to the witness to warm up. So they will ask some very mundane questions, background questions, very, very leading questions, etc. But what I do, what I have done, what I used to do, or what I do is a rapid fire approach. I will start hammering the witness with the most uncomfortable questions from the word go. I would not permit any warm up for the witness. So similarly, see, these strategies will depend upon the facts of every case. It depends upon individual to individual. I'm not saying my strategy is the best. Now, the other strategy could be that you ask some mundane questions to the witness and you try and understand his psyche in a few minutes. And then you get into a rapid fire. So these are highly subjective things. For example, when as a student, as a law student, when you used to answer the question paper, many would select those questions, the answers of which were the best. I mean, the best answers would come first. While many others, the best answers would come at the end. So this is very individual. But you have to understand the psyche of the witness. See, you don't get much time for a psychological analysis. First of all, you must understand from which strata of the society he is coming from. Is he educated or not? Is he a police witness or not? Is he a patently false witness? Has he been planted? Is he a witness to a recovery? Or is he an eyewitness to the main offense? So these are some parameters. With those parameters, you subjectively create an image, a psychological image of the witness. And then, as you go along the cross-examination, you will be able to find the trend. Now, let me give you an example. For example, there is a witness who has been tutored, who is super smart, who is over smart. And, then it becomes a challenge. And then whatever he says, he will only keep repeating the falsities. What do you do with such a witness? So I would normally drive him to absurdity. I would ask him questions and keep getting the false answers. I would drive him into falsity, something which is totally contradictory to the record. I would ask him many questions, and later on, because at the stage of arguments, then I would develop this argument that all these answers are totally contrary to the record. So he is a totally unreliable witness. Similarly, where witnesses, there are some witnesses who will give the same answer to every question. What do you do? In such cases, I would request the judge please note down all the questions and please note down all the answers, so that tomorrow at the stage of final arguments, you can argue that I asked X question, the answer is coming of a Y question. So the witness is evasive. So these are some of the ways, in which you analyze the psychology of a witness, and then you go on with the cross-examination.
Lovely, sir. Sir, इसी में what is the role of aggression? Like some people would want to use intimidation. Some people, some of them would be very sober, the most comfortable lawyer. So, ऐसे cases में how should we go about it? Does it help? And also, इसकी एक dynamic ये भी होगी that we are crossing our line. Some ethics laid down by the body, or some ethics that we should follow as as advocates. So legitimate advocacy के दायरे में रहते रहते, can we go into intimidation or other situation or other techniques that you would recommend?
Under the law of evidence, you can impeach the character of a witness in cross-examination. You need not restrict yourself only to the parameters of relevancy. You can go beyond relevancy. You can impeach his character, which means you can be aggressive in cross-examination. See, again, it depends upon the witness. It depends upon the cross-examiner. The great cross-examiner, Mr. Pandit Naseem, he's unfortunately no more. In the 80s and 90s, he was one of the finest cross-examiners. He would be extremely polite. He would be like butter, makhan. Makhan ki tarah, he would get all the answers from the witness which he wanted, and he would close the cross-examination. So that was his style. He would formulate the question in a way, making it so, he would package it so well, he would present it so politely, like a gift to a witness. And the witness would fall into that trap and answer, and he would elicit answers according to his defense. Whereas, I have been more of a aggressive cross-examiner. Rather, I have been aggressive or soft, depending upon the situation. See, it depends upon the wicket you bat on. When the wicket is in Australia and the ball is bouncy and the track is bouncy, spinning, you should not come out and try and hit a six on the first ball. You have to be defensive, and later on, you have to choose your shots. So it depends upon the terrain, it depends upon the witness, it depends upon the nature of the evidence, it depends upon myriad factors, which you understand by experience. So I would,
Right.
you can't really, but definitely some amount of intimidation. Let's not call it intimidation. Intimidation is like a threat. Let's not call it that. We can say you can be as aggressive as you want to be till the point of a threat. Till the point of a threat. You can even threaten the witness that I will sue you for perjury. I will send you to jail for perjury. Why not? There's nothing unethical about it. But what is unethical is if you try and influence the witness, or if you ask your client that please threaten a witness or buy him out. Those are the unethical practices. But when you are in the game, when you are playing the game of cross-examination, some amount of sledging is also permissible, I would say, if I may say so. But let the judge not hear you that you are sledging or you are doing something more than you are required to do. But it is fair. It is fair to be as aggressive as you can be in cross-examination.
Right, sir. सर एक रैपिड फायर आपके लिए. अगर मैं 100 में से पूछूं कि कितने % टाइम्स व्हेन यू डोंट नो व्हाट यू हैव टू डू राइट नाउ विद दिस विटनेस, 100 में से कितनी बार आप एग्रेसिव में जाएंगे, और मतलब कितनी बार काम किया है, चलो ऐसे बता दो, मतलब हाउ मेनी टाइम्स डज एग्रेसिव वर्क?
No, my ratio would be something like 70-30. You know,
ओके.
70% times I have been aggressive and 30% I have been, soft. And see, it all depends, it all depends. Many a times, if you're getting your defense from the witness, you're not required to be aggressive. But with over smart witnesses, over tutored witnesses, yes, I have been very aggressive on them, to the point that many a time the judges have had to, slow me down, or, they have told me, no, no, you can't do that and all that. But then I used to be, I normally be very aggressive, because again, I come back to the first point. Cross examination is the only instrument, it is the only weapon in the hands of the accused to establish his innocence. So therefore, why not? Why not? Why not?
राइट सर. ओके सर, एक चीज मैंने और भी सुनी है. आई आई गॉट इट फ्रॉम वन ऑफ द सीनियर लॉयर्स ओनली, and he told me that sometimes lawyers would take a team with them, अपने साथ दोस्त, ये जैसे if young ones are going, take a couple of friends with you, or if somebody who's experienced, take a team of interns with you who are in your team, and the person really feels a lot more load than a single lawyer cross-examining him. What do you think about that?
Yeah, you can adopt all kinds of strategies. Why not? If you can go with the 5 intern and 4 juniors, and maybe if the witness tends to get psyched by that, why not? Body language is allowed. I mean, there's no stopping. Nobody can stop. The battery of lawyers in the courtroom. If that can create a positive impact on your case and a negative impact on the witness, if you can confuse him, if you can intimidate him with the presence of a battery of lawyers, why not? All is fair in love and war.
Right, sir. सर नेक्स्ट वन, अब हम लोग तो प्रिपेयर हो गए, लाइक लॉयर्स हैव प्रिपेयर्ड देयर केस एंड एवरीथिंग. हाउ डू वी गो अबाउट प्रिपेयरिंग आवर क्लाइंट फॉर अ चीफ एज वेल एज अ क्रॉस? What would be the effective way of making sure that they don't make mistakes and they are spot on as far as their case is concerned, as far as solidifying their position in the case is concerned?
See, first of all, let me tell you, it is unethical to tutor a witness, in my view. You should not be tutoring a witness, but yes, having a conference with a witness, advising him, or, motivating him in an ethical way is fine. You're not crossing the Lakshman Rekha. So the best way to prepare a witness, to prepare your witness, who is going to be subjected to a cross-examination by the counsel for the other side, the best way, the most effective way is to prepare a cross-examination as if you are to cross-examine him. Prepare those 10, 20, 50, 100 questions, maybe on a piece of paper or a summary of it, or orally, or put it in your mind, or jot down the points. And ask him those very questions which you expect your opponent to ask him. I think that is the most effective way of preparing your witness who is going to be subjected to a cross-examination by the other side.
Right, sir. Sir, stemming out of the question that I asked about intimidation and aggressive cross-examination, one that I have received is, in case there is an intervention from the judge's side, and that happens a lot of times. While that, of course, is again legal, he's the one who has to maintain the decorum and do whatever he thinks is best for justice. How should a lawyer go about tackling or maybe taking care of the interest of his client in such a matter?
See, of course, I will just say a few words on this. First of all, preparation is the key. See, if you are ill prepared, if you are not prepared, then you are giving an opportunity to the judge to dominate the proceedings. If you know your off stump, if you know your case, you can actually argue and join issues with the judge on relevancy, on the principles of the law of evidence. See, if a lawyer doesn't know the provision of law which permits him to cross-examine a witness to impeach his character and his creditworthiness, and if the judge was to, stop him, restrain him, he will get restrained. But he's aware, if he's aware of the law, if he has all the arrows in his quiver, he will take the arrow and shoot it at the judge. No, I am permitted to ask this question. And of course, all what I am saying is aggression. Aggression doesn't mean you start boxing, you start pounding the witness over there physically. Please don't misunderstand me. All I am saying is you can be aggressive. Of course, there is a Lakshman Rekha. There is a Lakshman Rekha. And judges do tend to protect the witnesses these days. Because witness protection programs have come and all of that's come. But if you know your case, if you know your questions, if you have written down your questions exhaustively and your questions are relevant, no judge on this planet can stop you from aggressively asking those questions. The judge does not control the volume. You are not like a cassette player or a television system that the volume can be reduced by the judge, on the remote control. No, not at all. But at the same time, you can't act like a DJ in a Sangeet, where the neighboring courts are also hearing your pitch. No. So see, it's a balance. It's a balance. You have to be civilized. You have to be civilized. Being aggressive. You have to be aggressive and yet be civilized. So therefore, judges don't normally stop lawyers from cross-examining unless you are so repetitive, unless you are ill-prepared, unless you don't know your case. I have seen so many judges ridicule the lawyers cross-examining the witness. वकील साहब, आपको पता ही नहीं है आपका क्या डिफेंस है. अरे वकील साहब, मत पूछिए ये सवाल, ये आपके खिलाफ जाएगा. See, if you are going to be so vulnerable because of your non-preparation, ill preparation, you don't have a clue of your defense, and you start cross-examining the witness, then why blame the judges? The judges will definitely admonish such lawyers, ridicule such lawyers, laugh at such lawyers. Why not? So I come back to the first principle. Preparation. Hard work. Not Harvard. It is hard work in cross-examination. I've always believed in hard work, not Harvard.
Right, sir. Sir, इसी पे बस just to close down on the conversation on this particular question, what if, just to suppose, some judge is actually biased and he's badgering and he keeps on telling you or intervening or something like that, हम प्यार से कैसे बोले कि साहब हमें आगे बढ़ने दो, या फिर we just let it be and हम फिर revision या appellate?
There's no question of letting it be.
Okay.
You have to be tactful. Judges are judges. After all, a judge is presiding over a criminal trial. I remember, about 15 years back, I was engaged to defend one of the accused in a CBI criminal trial. And I was polite, I was tactful, I was well prepared. Whereas one of my contemporaries was very aggressive in cross-examination. And to the point that the judge also would keep warning him 20 times, 30 times, all the time. and there would be skirmishes between the two very frequently. Ultimately, what happened? Ultimately, the lawyer had his way when he cross-examined the witnesses so aggressively to the point that the judge would be highly, very, very unhappy all the time. What happened at the end of it? My client was exonerated, acquitted, and his client was convicted. And let me tell you, sentenced to imprisonment more than 3 years. So that litigant, that accused, went to jail before he was granted bail by the High Court after spending 3 months in jail. See, a judge of a criminal trial, he's after all going to decide your client's destiny. So you have to be tactful. By aggression, I am not saying you intimidate the judge or you make the judge unhappy. And I am telling you, I am repeating this. If you are well prepared with your questions, if you are well prepared with your case, judges normally don't restrain lawyers. And even if they do, you tell them, I have a question here. I will not repeat, but I have questions. All these questions are based on relevancy, the principles of relevancy. They're all based on principles of law of evidence. Still, if the judge refuses to grant you more time to cross-examine, or the judge says, no, you shut up, and you conclude within 10 minutes, then you challenge the order before the higher forum. There is a tendency these days for judges to be very interventionist. Arey vakil sahab, khatam kariye, jaldi khatam kariye. But normally, judges will say that in cases where they find that the lawyers are talking in the air. They're not well prepared. Normally, 99.99% judges appreciate good questioning, good cross-examination by lawyers. Judges don't, for the heck of it, they don't intimidate lawyers or restrain or refrain lawyers. No, it doesn't happen like that. So therefore, I come back to the first principle, the first mantra, hard work. Be well prepared with your cross-examination. That's it.
Right, sir. सर आपने अपने एक्सपीरियंस में बहुत सारे लॉयर्स को देखा होगा, यंग लॉयर्स एंड older lawyers also, and you've seen where they make mistakes. So if we were to list out 3 super common mistakes that young lawyers are making, or lawyers who are not good at the trade right now are making, what would they be and उनका कैसे निवारण हो सकता है?
Okay. Firstly, most lawyers are ill-prepared. They are not prepared. Now, firstly, the first flaw. The second flaw, over cross-examination. Over cross-examination means you are, through your questions in cross-examination, you are filling up the lacunas in the prosecution case. If there are shortcomings in the prosecution case, if there are lacunas in the prosecution case, please do not fill them up with your questioning in cross-examination. Second grave error. And therefore, the third error, which is a fallout of the second one, it is a corollary, it is a fallout of the second one. It means you should know when to stop. You should know what not to ask. What not to ask is as important or more important than what to ask, when to ask. So these are the 2 or 3 serious flaws which I see in lawyers, in inexperienced lawyers who don't prepare their cases well. These are the flaws in their cross-examination, which are very frequently seen in the courts.
Sir, can I request you for a quick example of 2 and 3? मतलब where do we have to stop? कैसी सिचुएशन में हमें पता चलेगा अच्छा हमें यहाँ रुक जाना चाहिए, because most of the lawyers what they think.
So okay, now let's lay down the principle of Lakshman Rekha. So see, the moment you have brought out your defense from the mouth of the prosecution witness, the moment you have got that, You have to stop. Secondly, you have to ask all questions because very frequently another flaw which I find in cross-examiners of today is they don't ask the questions, the significant questions. So many a times in the judgment, you will find the judges writing that on this material aspect, there has been no cross-examination. Therefore, this particular fact stands established because of no cross-examination. And another flaw, rather I would say another mantra, never ask the nucleus question. Let's take the example, in a case where there's a stabbing, the allegation is that the accused stabbed the deceased. Now there's an eyewitness. Never ask the eyewitness, did you see him stab the deceased? Obviously, he will say yes. Never ask the nucleus question. Ask the peripheral questions. आप कहाँ थे? कितना बजा था? कितनी लाइट थी? रात का समय था? कितनी दूर खड़े थे? आपका मोबाइल कहाँ था? So you ask so many of these peripheral questions from which the inference arises कि आप वहां पे नहीं थे. अगर आप थे भी तो लाइट नहीं थी, लैंप नहीं था वहां पे, फॉग थी, विंटर का सीजन था, और यू आर अ प्लांटेड विटनेस. You know the complainant's family very well. You are related to the complainant. You have been planted. Never ask the nucleus question, that one question. Did you see the accused shoot at the deceased? Obviously, he will say yes. And that is harakiri. उसको आप suggestion में लाइए. That what you have said, you never saw him stab the deceased. You never saw him shoot at the deceased. These are some of the. See, this is what you learn, out of experience, or when you train with super cross examiners of their times.
Right, sir. So next one is, while we have some strategies for general cross examinations, is there anything specific we should be following when we are talking to an expert, a medical expert, or a police personnel, or somebody who's an officer? तो उनके लिए कुछ अलग से सोचा जाना जरूरी है?
Yes. So you should have the knowledge of that area, the area of expertise. You should have knowledge of that. And secondly, you should have enough material with you, enough scientific material to contradict the expert. First of all, you must have a thorough study of that area. Secondly, you must have scientific material to contradict him. Thirdly, you must confront that material to him. No, you have to confront him. You can't just ask him and later on bring that material through a defense witness. No. You have to confront that material by which you want to contradict the expert. So these are some of the important facets when you are cross-examining expert witnesses.
Right, sir. Sir, falling back to the last question that we talked about where to stop. Now, while it is important to know कि हमें कहाँ रुकना है, we have to be limited to a certain extent. हम सारे questions नहीं पूछ सकते. वहीं पे ये भी डर है कि जैसे आपने बताया, जज साहब कहेंगे कि इस चीज पे इन्होंने कोई क्वेश्चन पूछा ही नहीं, वो हमारे खिलाफ जा सकता है. तो ये दोनों चीजें लॉगर हेड्स में आ जाती है. So, what skill do we have to acquire and how?
Kindly repeat this. Kindly, I want to understand.
हाँ जी, yeah. So, जैसे सर हम लोगों ने बात करी कि क्वेश्चंस जो हमें पूछने हैं, वी हैव टू लिमिट आवरसेल्व्स, वी हैव टू नो वेयर टू स्टॉप. जो चीज नहीं पूछनी वो ज्यादा इंपॉर्टेंट है. बट इन ऑर्डर टू लिमिट आवरसेल्व्स, हम लोग कम से कम क्वेश्चंस पूछें, न्यूक्लियस की तरफ जाएं, बट देन ये भी डर है कि हम कुछ ऐसा छोड़ ना दें जहां से हमें कुछ अच्छा मटेरियल मिल सकता था, एंड द जज लेटर ऑन राइट्स इन द ऑर्डर कि इन्होंने ये इंपॉर्टेंट बात पे कोई एक क्वेश्चन ही नहीं पूछा और वो हमारा नुकसान हो जाए। तो ये इस चीज को आइडेंटिफाई करना अपने आप में एक स्किल है, विच आई नो एक्सपीरियंस से आएगा और बहुत सारी चीजों से आएगा, बट इफ देयर इज वन थिंग वी कैन वर्क ऑन, वन स्किल वी कैन वर्क ऑन, एंड हाउ?
Yes. So, okay, I will formulate this very clearly for the young lawyers. In any criminal case, the incriminating facts are few. Narrow them down. And then the witness concerned, what is his connectivity with the incriminating facts? For example, expert witness hai. He is concerned about the medical condition of the deceased. Ballistic witness hai. He is concerned about the gun, the weapon. Suppose handwriting expert hai. He is concerned about the handwriting. There is an eyewitness. He has seen the incident. There is a recovery witness before whom the items recovered from the accused were seized. So each witness has a role. You must understand that role. And you must know the incriminating facts of the case. And keeping in view the incriminating facts alleged by the prosecution and the role of the concerned witness, you craft a cross-examination. And that's where then you know that ये role है, ये incriminating facts है, ये मेरा defense है. Once you have these three things clear in your mind, you will know where to stop. I can't tell you every sentence. I can't tell you that there will be a comma after the third word or the 98th word. Depends. Depends upon the sentence. Depends upon the poem. Depends upon the song. So once you have these preparatory parameters in place in your mind, you will know where to stop. I promise you, I assure you, you will know where to stop.
Right, sir. Sir, somebody has suggested in the chat box that Where to Stop should be your ninth book.
Where the?
Where to Stop could be the title of your ninth book.
No. My ninth book, I have titled, I have the title in my mind. I'm not disclosing it right now, but something which is as interesting as chaff and grain. So okay. I have something in mind, but I don't get the time. I'm busy with my election campaign for the presidency of Delhi High Court Bar. Maybe after I'm done with that, then I will plan something into the future. See, writing a book is like delivering a baby, like delivering a child. So it's a lot of hard work. You get consumed. You get totally consumed. So therefore, I have done 8. Now I need a bit of a break for 2-3 years. So
okay,
therefore, my ninth one, I hope will come sometime in the end of 2026. I have the title in my mind.
ठीक है सर, maybe
10th right now.
Right sir, maybe 10th 11th कहीं जाके LCI के यहाँ से आपको लगे कि
वो तो देखो, that is a dream. I wish I can leave a legacy of one shelf full of books authored by me for my children.
Of course, sir.
That is my dream. But I am so busy professionally also. So time, you need time. A pandemic में time ज़्यादा था because everything was happening virtually. I would do my virtual hearings and then I had time on hand. So I could write 3 books during the pandemic. Now time is, at a premium. Time,
right, sir.
There is paucity of time all the time.
Right, sir. Sir, we have 10 minutes and 2 questions to go. Maybe we can, incorporate some of the questions in the chat box also. Now, the next question is, sir, you are pacing with time and, like they say, aging like a fine wine. So, आप टेक्नोलॉजी के साथ भी चलते हैं. courtrooms में technology is now playing a huge role. It's playing its role in every aspect of life. But how do you think young lawyers and the old ones should pace along using technology? Where have you incorporated technology?
Oh, technology can play a very important role in cross-examination. I can see that. Many times what used to happen when I would be having the examination in chief of the witness, I would have to cross-examine. I would want to pick out certain sentences. Now, then, then you didn't have AI and you didn't have so many things. But now with technology, you can segregate, you can classify facts, you can segregate data, segregate the facts, etc., etc. So technology has become very important. Even in cross-examination, it can be very effectively used. And I am also adapting to technology. Of course, the younger lawyers are much smarter than my generation. They are much more techno savvy. They are able to use technology much more effectively and efficiently to their advantage. So therefore, here I would say that the young lawyers are ahead in time. They are ahead of veterans like me. And they are the future of the bar. They are way ahead. They are much smarter as a generation, than my generation. It's only that I have more experience. Otherwise, in terms of intelligence, commitment, etc., etc., the younger generation is far more diligent, far more focused than my generation. I must concede that. And that's how it should be also. The bar, the young members of the bar are the future of the bar. They are the future of the judiciary. So, but yeah, coming back to your question, I am adapting to technology, but the younger lawyers in my office are, super efficient. They keep teaching me, different aspects of technology, and I'm happy. I'm a very happy student when it comes to technology. Even otherwise, I'm a student of law. I'm still a student of law.
Right, sir. ठीक है सर, इस क्वेश्चन के लिए फिर मैं आई आस्क द यंगर वंस इन द मीटिंग कि आप लोग अपने सजेशंस चैट बॉक्स में लिखें. हाउ आर यू यूजिंग टेक्नोलॉजी? लाइक हाउ इज इट हेल्पिंग यू इन क्रॉस एग्जामिनेशन एंड एवरीथिंग? सर, लास्ट क्वेश्चन दैट वी हैड ऑन द बोर्ड, I'll ask that, and if we have some quick questions, if people can frame them very briefly, तो I'll take them. Last one is, sir, suggestions के बारे में आपने बात करी. Many of us do not really understand suggestions. किस लिए हैं law में? Why? How is that a tool? And how should that tool be used effectively?
Yes, yes. I have to explain this.
जी.
Empty suggestions are meaningless. At the end of it, it is wrong to suggest that, I have deposed falsely. All that is meaningless. Your suggestions must be your defenses. You must put your defense in the form of suggestions. But you have to lay down the base in the body of the cross-examination. So this is how suggestions come. Otherwise, a suggestion, it is wrong to suggest that you were there. It is wrong to suggest that you are an eyewitness. It is wrong to suggest all that. Oh, that is meaningless unless that base is created. Just the way I explained, okay, the light was not there. It was darkness. You were standing 20 meters away. You are a planted witness, etc., etc. Once that base is created, then you give a suggestion. Otherwise, empty suggestions are meaningless.
Right, sir. Now, sir, do we have 5-10 minutes?
5 minutes, because I have a conference starting
No
at
problem, sir.
8:15. Some clients are going to log in from Toronto. So, I
Okay,
have
sir.
to be there by 8:15. So we have about 5-6 minutes.
ठीक है sir. I'll take up the questions in the in the chronological order. First one I see is from Mr. Sushil, and he is asking, can we put documents during cross-examination which are not a part of the court record?
Yes,
If
you
yeah,
can, but there are in criminal law, in criminal cases you can because there is no stage for filing documents for the accused. You get my point? There is no stage. Whereas in a civil case, there is a bar because there is a stage. There is a stage at which you have to file all your documents. But in civil cases also, CPC has provisions. You have to seek the leave of the court. And then you have to explain why didn't you file the document earlier. See, let me explain. You can't take, in civil cases, you can't take witnesses by surprise. No. In criminal cases, you can. So there is a distinction between the two. So with exceptions, in civil cases, judges may not permit you, but you have to make out an exceptional case. Why did you not file the document earlier at the relevant stage? Why? Why now? Explain it. But
right.
in certain exceptional situations, you can confront the witness with a document that is not a part of the record. In criminal cases, it can be done.
Right, sir. सर वीरेंद्र बग्गा जी पूछते हैं कि नॉर्मली क्रॉस जो है वो कॉर्नर ऑफ द कोर्ट में करी जाती है एंड जज इज नॉट लिसनिंग टू व्हाट इज हैपनिंग मेनी अ टाइम्स सो कैन वी ऑब्जेक्ट टू दिस प्रैक्टिस?
See, you should not. You are hitting the judge below the belt. You should not. Maybe you can just you can prod the judge. See, judges are overburdened with work. Although the law is very clear that the judge should not be a mute spectator in cross-examination. A judge is not a mere recording machine. When the evidence is being taken on record, when cross-examination is happening, he has to be a participant. He has to observe the demeanor of the witness. He has to observe. He's the judge. He's like an umpire. He has to be aware of what's happening. But it doesn't happen practically every day. They are burdened with so many cases. So a typical judge, not the sessions judges are all focused, but chief metropolitan magistrates and the other judges who are multitasking. So some cross-examination is happening under, within their hearing. And they are doing some miscellaneous work also. But you can politely tell the judge that if the judge could, devote and focus on the cross-examination, that may be a good idea.
Right, sir. Sir, if I may, I would just briefly add on something that I have actually witnessed. One of the senior lawyers here in Dehradun had actually put some objection like this under section 273 of CRPC. And he took out a judgment from the Supreme Court's records, whereby it was stated in the judgment that 273 says evidence has to be taken in presence and hearing of the accused. That is what 273 says. And the same thing also applies to the judge. So इस तरह से उन्होंने कुछ examination में irregularity.
So therefore, I've said, the case law, Supreme Court has said time and again that a judge is not a mere recording machine. He is not a mute spectator in a criminal trial or a civil trial.
Right,
Meaning thereby, he is an active participant. But you have to take these objections very tactfully. Otherwise, you face the risk of losing the case.
जी sir. Okay, sir, I'll wrap this up here. You have your conference in about 5 minutes. So just thanking you from everybody's end. We have almost 75 questions right now on Zoom and on social media. जो cover नहीं हो सकते, मेरे ख्याल आपकी किताब की wait करनी पड़ेगी हमें. But I would definitely invite you in advance for another session whenever you find time. because these are enriching sessions और इससे बहुत फायदा होता है सर सब लोगों का.
Thank you for bringing me on this platform. It was a pleasure to speak about one of my favorite subjects, and that is cross-examination. Thank you.
Thank you so much, sir. It was a pleasure. Thank you everybody who joined on a Sunday evening. We'll see you again. We keep on having various sessions on laws with different lawyers and judges and esteemed people. So do check out the link that I had shared in the chat box. Go to the learning page lawyersclubindia.com in case you want to get in touch with me about writing, about publishing your articles, getting digital presence, uh, e-learning courses. If you want to teach on Lawyers Club India, there's a lot that you can do. You can get in touch with a lot of clients on Lawyers Club India. There's a forum where we have almost 35-40,000 people coming and talking about law. तो आप उनसे interact कर सकते हैं and there's a lot of activity happening. Do check out. I'll share it once again. I'll share my phone number as well. And in case you have any queries, you can talk to us. Also, anybody who's started using technology and can share it with us, do share it with us through any medium. If you can share it right now, we are here. I've shared the link and the number. Please note, please visit and put in your suggestions as well. In case आप लोगों को लगता है some session on some topic can help from certain lawyer, we can arrange that. We keep arranging such courses and sessions, and it would be lovely to interact with you. All right, guys. Once again, have a great evening ahead. Thank you so much. Join us again. Good night.